Hi, this is Curt and welcome to another edition of Fire Law Roundup.
So let's start with New Jersey. This is going to be a trend. If it hasn't, this is very much a big deal in New York, New Jersey. I'm sure there are other states. In New Jersey, a fire department has now been held liable for a sexual assault, child abuse that occurred 30 years ago. And if you're saying, are you sure 30 years ago is right? Yes. What happened in New Jersey, New York, I imagine some other states.
I don't think so.
Oh, really? Oh, okay. I mean, New York's
it's
crazy,
something.
but
I think it's pretty unique. But
wow. Okay, and in New York, it was Governor Cuomo who had his own problems with this. Even funny. So, but nonetheless, not. Look, the Boy Scouts nationwide have been. This is what I'm saying. They're going bankrupt. Have declared bankruptcy. I'm defending a lot of these suits. I'll explain them in a second, but. So what happened in New York and New Jersey, and that's I was thinking, since the Boy Scouts are pretty much bankrupt or declared bankruptcy nationwide, that maybe this is more widespread. In any event, New York and New Jersey enacted laws that basically revived the ability of a victim of sexual abuse up till any years ago. It doesn't matter. New York is like 200 years or so. It was a crazy time, but that any living victim can now pursue not only the offender, but also the fire department. There's some important language in here that I want to use for people who have junior programs. It is very important. That's why we're kind of highlighting this. In any event, they've been found to pay $300 and some odd $1,000 in liability. There was already a $4.7 million judgment years ago, but the guy defaulted. He was in jail. So everyone understands the person was convicted. The assailant was convicted already, sentenced to 10 years in prison. Now they go after the victim, but also the fire department and the city. And this is what's important. And now we're kind of quoting the victim's attorney, but the lawsuit focused on failure to properly supervise, failure to properly train personnel who were participating in the junior program. And the attorney said something that I really agree with.
Brad, I'm not sure that this is actually a junior program. I think that this person just brought the victim into the firehouse. And I agree with everything that you're saying. I agree with everything that you're saying, that junior programs need to be attentive. I'm not sure that this was actually a junior program.
There was a 12-year-old boy who was assaulted by the individual when he was a firefighter.
Right.
I guess that kind of makes sense.
In the firehouse.
In the firehouse.
And they felt like he was using the firehouse as sort of a place to bring them.
Oh,
that's my understanding. But so it could be. It just, all I know is there was nothing in nothing in anything that I read that said it was a junior.
Okay.
So that's why I would.
Let's kind of use that, right, and talk about this. There's two options, though. So first, if it was an actual program where, juniors are brought in and, they spend the night or they're trained or whatever, then look, the fire department has an obligation to properly screen, to the extent you could do that, properly screen the members who are going to be dealing with the youth, but also to train, and I'll go further, also to have policies that ensure, like the one I always say, if you have somebody under 18 in the firehouse, there are no fewer than 2 adults in the same room. I prefer 3, but 2 adults. And for this, I define as an adult as 21 and over, not 18, because sometimes you get too close in age.
And just we refer to that as too deep leadership. That's the term. That was actually something that the Boy Scouts, I believe, developed, but they call it too deep leadership. And that's a good principle to have in the policies. Absolutely.
Yeah. And then look, now let's go the other way. If your other suspicion is correct, that they were just, this person was just bringing the 12-year-old boy in and sexually assaulting, then in that, I'm kind of like, how the heck does the fire department lose? Right, unless they had some knowledge, what would you train somebody in? So
I think that's the point, that we've got to be aware of the prevalence of pedophilia, and that when you have a certain member that is bringing, and this particular youth was not the only one that this particular gentleman was bringing into the station. There were a couple of others. Now, he's only being sued by one of them, but there were a couple of others. But as a supervisor, if you're aware that one of your firefighters is bringing in a child that's not his or her own child, into the firehouse on a regular basis, on an ongoing basis. And apparently there was at least 30 different instances where this happened. At some point, you've got to be attentive to these. You can't just ignore it.
Right. And look, we could make up facts. For example, right. Hey, children, why don't you come see the fire truck, right? And we're using the fire truck, the firehouse, as a lure to get them in. And I suppose if the fire company, the fire department, knew that somebody was bringing them in to show them, and they were actively giving tours, and then, but wow, I mean, that's anyway, yeah, I get it's just crazy stuff.
It's mind-boggling. And you might know, I'm not sure if Perth Amboy is a career department, or is it a city with a career department? Is it a volunteer department? Or
I don't know.
I don't know the answer to that either. So but at any rate, it happened. The perpetrator was sentenced to 10 years in prison. And, on the earlier suit where the perpetrator was awarded, or the perpetrator was ordered to pay $4.75 million, somebody like that is judgment proof. He's in jail now. He'll never be able to pay, even if he pays $5 a week or $10 a week, whatever the court may order. Never going to get anywhere near that. And so the next most logical party to go after,
right, the fire department. But let's think about this. So intentional acts, this is why I love this. Hopefully everybody else finds this as interesting as Curt and I do, because we could hang up and keep talking about it. But, think about this from the liability, the insurance side. Now, and I say this and everyone always says, oh, there's no insurance, we're off the hook. No, if there's no insurance for something, which is what I'm going to throw out, you're still on the hook. You just are paying it out of your own pocket, right? So we don't know that happened. But what leads me to believe that the fire department maybe didn't know, or I don't know, is intentional acts are excluded from insurance coverage, right? Intentional illegal acts and criminal acts are excluded. But here it sounds as if it was the allegation sounded in negligence, that they negligently supervised. And that would not necessarily have been excluded from insurance coverage because they weren't doing the act. However, you could say, I've said this so many times for our longtime listeners, it's like the state park police who rapes somebody. This is a true case I had, who raped somebody, right, at the park, and the park gets off the hook, the government gets off the hook saying, listen, that wasn't as part of his job duties, because raping somebody isn't part of their job duties, so their employer doesn't have to pay. So to here, you'd think the insurance company and the fire department would say, hey, that's not our duty. Now, on the other hand, you and I have created well, wait a minute, but if you're constantly bringing youth in as a fire prevention program, it is your duty. Maybe it should be covered, or maybe not. I don't know. There's so many questions we don't have answers to. But
there is. And just to clarify, what we're talking about is the difference between suing the individual perpetrator who did something and the fire department for what we call respondeat superior, which is you're the employer, therefore you're liable. You're the employer, you're benefiting from the employee, you're liable for what the employee did. You can't recover for intentional acts under respondeat superior because it's outside the scope. Okay, but what they alleged here was that you were negligent in your supervision, and there's a whole line of cases. Negligent hiring, negligent retention, negligent supervision, and negligent training. All of those go in there. Those are negligence claims, and the scope of employment would not be a defense, right? Yeah. It should be covered. Now, the reason I'm going through that is I've got an interesting case I discuss a lot in my discipline class. The name of the case is MP versus City of Sacramento. And it involved firefighters who allegedly sexually assaulted a woman on duty. And the court said that we're not going to entertain the negligent supervision claims because it was outside the scope, and that would just be a way to get around it. So I think that's a California case. I'm not sure. I don't think it's going to be good law virtually anywhere else, but
except maybe
at
New
least
York, who's just as,
well, but they basically said, we're not going to hold the city liable, and we're not going to allow you to use those kind of claims to hold the city liable. So we didn't see that, at least as from what I've read from this case, as being an issue. But it's not an uncommon scenario, and it's something that we should understand.
Yeah, and really, just before we transition to Connecticut for a second, everybody should understand, if you're bringing youth in, I don't care for what purpose, you're doing it under the lure of fire protection or whatever, you've got to supervise them, you got to train them, and like we said, don't leave them alone with one adult. Two is even kind of scratching the surface, but we have to be careful, and I'm not saying that people don't deserve compensation. These 30-year-old suits, again, I have 13 of them we're defending in New York, and the assailant is dead in most of them, and there's no insurance coverage because it's 30 years ago, or 40 years ago, 50 years ago is one of them I have. I mean, you can't defend these.
Yeah, they really, you would have thought the legislature, and I would say this to any legislature that's thinking about this now going forward, you may want to limit the liability to the actual perpetrator and not to the organization. Because if it really, I think what most of these cases are is they're looking for vindication. And if you that's what you want vindication, you want to be, acknowledged as being the victim, then you can do that through an award against the individual. But holding the entity liable, it's the taxpayers. It's not the taxpayers today, not the taxpayers 30 years ago, 40 years ago, 50 years ago. It's today's taxpayers.
Right. I'm opposed to it, and people got upset at me for saying, "Oh, you're opposed to victims recovering." No, I'm opposed to the fire departments and the taxpayers paying.